Hello students, today, we are going to take a deep dive into a very important foundation of labor legislation in India, the Constitution of India. Now, why is this important? Because the Constitution is not just a book of laws, it is the moral and legal backbone of our country. Every labor law, whether protective, regulative, or welfare-oriented, finds its legitimacy in the provisions of our Constitution. Let's begin with the preamble. When we read the preamble, words like democracy, socialism, liberty, justice, equality, and fraternity stand out. These are not ornamental words, but guiding values that directly connect with workers. Democracy gives workers the same political voice as their employers, through one person, one vote. This equal status is revolutionary when we think about how workers were treated in ancient and colonial times. Socialism ensures that workers, the weaker sections, are not left at the mercy of profit-driven employers. For example, the Equal Remuneration Act, 1976 embodies this spirit by ensuring equal pay for equal work. Liberty and freedom empower workers to speak against injustice, form unions, and demand fair treatment. Justice, whether social, economic, or political, is central. It ensures that labor is not treated as a commodity but as human beings with dignity. Equality eliminates discrimination on grounds of caste, gender, or religion. And fraternity, a sense of brotherhood, is essential for dignity of labor, so that workers are seen not as tools, but as partners in nation building. So you see, even before specific labor laws, the Constitution planted these values in our system. Now, let us move to the fundamental rights. These are enforceable by courts, which means if a worker's rights are violated, they can approach the judiciary. Some of the most relevant rights are: right to equality, Articles 14 to 17, guarantees equal opportunity in employment, prohibits discrimination, and abolishes untouchability. Imagine a Dalit worker being denied entry into a factory canteen. Article 17 makes this unconstitutional. Right to freedom, Articles 19, 21, 21A, workers can form associations, join trade unions, and move freely in search of employment. The right to education, 21A, ensures that children are not forced into factories but attend schools. Right against exploitation, Articles 23 to 24, bans bonded labor, trafficking, and child labor. Next, we turn to the directive principles of state policy. These are not justiciable, meaning, workers cannot go to court demanding them. But they are binding on the government as guiding principles of governance. They shape long-term labor policies. Let's look at a few. Article 38 says the state must promote a social order based on justice, social, economic, and political. Article 39 directs equal pay for equal work, protection of health, prohibition of child exploitation, and development opportunities for children. Isn't this the basis for our Equal Remuneration Act, 1976 and Child Labor Act, 1986? Article 41 talks about right to work, education, and assistance in cases like unemployment or sickness. This principle paved the way for schemes like MNREGA. Article 42 ensures humane conditions of work and maternity relief, inspiring the Maternity Benefit Act, 1961. Article 43A encourages workers' participation in management, leading to joint management councils in industries. So while fundamental rights are the shield, directive principles are the compass that directs the government's path in labor welfare. Now, let's understand the distribution of legislative powers under Article 246 and the 7th Schedule. Labor is a subject spread across all three lists: union, state, and concurrent. This means different aspects of labor are handled at different levels. In the union list, subjects like railways, shipping, banking, insurance, mines, oil fields, and interstate migration fall under Parliament's jurisdiction. For example, the safety of coal mine workers is a central responsibility. In the concurrent list, both center and states can legislate. This includes trade unions, social security, welfare of labor, factories, maternity benefits, etc. For example, both Parliament and a state assembly can make laws on minimum wages, though if there's a conflict, the central law prevails. In the state list, matters like prisons, relief of disabled persons, betting, gambling, and state pensions come under state legislatures. This distribution ensures both national uniformity and regional flexibility. For example, states can create their own labor welfare funds to address local needs. Finally, the Constitution also provides coordination mechanisms. Under Article 245, Parliament can even pass laws with extraterritorial application. Articles 256 and 257 empower the Centre to issue directions to states to ensure compliance with labor laws. Under Article 258, the Centre can delegate powers to states for implementation. And most importantly, if there is ever a contradiction between a central and a state law on a concurrent subject, the central law prevails. Let me wrap this up with a quick reflection. The story of labor legislation in India is really the story of how constitutional values translate into real protections for workers. The preamble gives the ideals, fundamental rights provide enforceable safeguards, directive principles guide policy making, and the seventh schedule defines who makes which law. So whenever we study any labor law, be it the Factories Act, 1948, Minimum Wages Act, 1948, or the recent labor codes, we must remember that their roots lie deep within the soil of the Constitution of India. And that, students, is why labor legislation is not just a legal framework, but a reflection of our constitutional morality. Dear viewer, if you found this video useful, we kindly request you to subscribe to our channel. Your likes, comments, and shares truly encourage us to create more such content. For free PDF notes and free multiple choice question practice on this topic, please visit our website. The link is provided in the description box. Thank you so much for watching and supporting us.